We'll be joined shortly by Philip Hamburger. He is the author of Is Administrative Law Unlawful? Philip Hamburger is the Maurice and Hilda Friedman Professor of Law at Columbia Law School. He's the author of Law and Judicial Duty and Separation of Church and State. The book, Is Administrative Law Unlawful, deals with the rather thorny and contentious question of where does constitutional law begin and end, and where does constitutional law, which is, of course, law that is made by the U.S. Congress, Article 1, Section 8, become administrative law, and the balance between the two. Administrative law, I think, is defined by laws that are made by either judges, bureaucrats under the auspices of the executive branch, or by executive order. Philip, thanks for joining me this afternoon.
Thank you. Good to be here.
My pleasure. Your book deals with the question of administrative law, whether it is unlawful. Could you, first of all, define administrative law in the present usage?
Okay. Thank you very much. Well, we talk about administrative law, particularly in law schools, of course, and that very name gives it a sense of legitimacy. It suggests that it really is a sort of law. But, of course, it isn't. The laws under our Constitution consist of the Constitution itself made by the people or statutes that are made by Congress. And nowhere in the Constitution does it mention executive commands or diktats or edicts. And it's that which mainly is the core of administrative power. Administrative power is what my book actually describes as extra-legal power or extra-legal lawmaking, in the sense that normally the government controls us through the laws. It uses the laws to command us, control us. And that's okay because these laws are made by our representatives and it comes in the form of law. Administrative power, however, is a curious thing because it doesn't apply to us through the law. It applies to us through other means. And that's why what most people call administrative law or administrative power, I think is more accurately described as extra-legal power in the sense that it comes not through law but through other mechanisms, through mere commands.
Would it also not therefore be true that under Articles 9 and 10 of the amendments, states reserve the right to also make law based upon their own state legislatures that are not specifically delineated to the federal government by the Constitution?
Yeah, that's right. We have a federal system, and the federal system means that the broadest sphere of power actually is in the states, in the state legislatures, and only limited enumerated powers have been given by the people to Congress. And so there's a very specialized limited power in the federal government. That appears in Article 1, and also it's sort of backed up by the amendments you mentioned. But those limits on federal power have long since passed, I'm afraid. And unfortunately, these days, it's the states as well as the federal government engaged in administrative authority and power.
Right, exactly, that there are these extra-legal laws. I want to talk a little bit about how this is actually implemented. And my understanding is that there are several aspects to it. First of all, of course, you've got judicial fiat, where we have judges making law from the bench, essentially interpreting the Constitution, whether it be state or federal, as if they're having a constitutional convention. And, in fact, there have been several federal Supreme Court justices who have even made reference to this, including Brennan and Warren in the past. And that is that you get special interests that will increasingly go to the courts rather than to state legislatures or the Congress to get laws passed, because that way they can have it done by command. The second aspect is the establishment of bureaucracies. And the bureaucracies are able to make laws. Of course, they call them something else. They call them, mandates, regulations, I don't know, whatever they want to call it. But they are laws. And you have an example of that with the workplace discrimination laws that are made by the EEOC and many, many other areas. This goes back to the Lincoln administration and the founding of the Interstate Commerce Committee, ICC. but it's something that's proliferated in the 20th century, particularly starting in the 1930s. And then the third area is presidential directive. That is the use of executive orders to make laws, when in fact executive orders traditionally have dealt with either specific regulations pertaining to the executive branch or to ceremonial decrees, like President Washington in the first year in office declared a day of Thanksgiving and prayer, that being Thanksgiving, and President Grant made Christmas a legal holiday by executive order. But beyond that, you never had a situation where a president, by executive order, would make policy like immigration policy, which is what President Obama is now threatening to do. So are those the three areas that you would define administrative law?
I think that what you described nicely captures much of the range of extralegal power. My book actually focuses merely on the second of yours, and I guess also the third, namely the use of power by the executive, be it the president or one of the departments or other agencies of the federal government, to control us not through laws but through their mere commands. And I suppose one could have, as you do, take an even broader view of it. But there's only so much you can do, even in a long book. And
No, I know it, and it's a very comprehensive book, by the way. Okay. Now, I had a guest on the other day that brought up questions in my mind that I specifically wanted to ask you about, and that was Cliven Bundy. He was the rancher who got in trouble when he came across the Bureau of Land Management basically confiscating his cattle. And I discovered in the course of conversation with him that this is a problem that's endemic in the western states. It's not even an ideological question. You got liberals and conservatives who are concerned over the fact that the federal government in the western states controls about 2/3 of the land surface and manages it, and did not cede it to the states, which they had done in the eastern states when they became states. Now, is this whole structure upheld by administrative law? And what is the legal basis for the federal government to be managing vast tracts of territory west of the Mississippi?
Right. So this is a very interesting problem, and it's complicated because the federal government owns the land. And at first glance, this would suggest it should have very considerable control over what's done over it and over the people who reside on it. Now, it's a little different from the administrative power I've been looking at, because the administrative power I've focused on in my book is where the executive exerts direct control through its regulations, commanding one. In contrast, the Cliven Bundy situation, the federal land situation, is a sort of situation where the government gives benefits. Sometimes, it gives money to universities and exerts control that way with the conditions on the money. And sometimes, as in the West, it uses gives the benefit of federal land to folks and then uses that as a mode of control by placing conditions on it. And that's really what the federal land problem is in the West. Now, although that's not the sort of administrative power that I've been focusing on here, it is a sort of extralegal power. The government is meant to control us through laws, and we should live in a republic in which we're governed through laws made by folks whom we elected, whether we win or lose the elections, at least the folks elected by the people. The federal land situation, and indeed all the instances, for example, in universities where the government gives money and then puts speech restrictions on it, are instances where the government is unable to pass a statute controlling us. So instead, they use this apparent gift or benefit of land or money to institute controls. And this is what in law is called an unconstitutional conditions problem. Now, not all conditions are unconstitutional, but this is not the way in which the government should be controlling our lives. It really is a sort of backhanded way of control, and the Supreme Court has not figured out really how to deal with this yet, and it really deserves more attention. I've written on it in an article.
Where does the government derive its claim to have the money, the resources, to control that land? I mean, what did they do? How did they raise that?
Right.
Those funds?
Territories.
What's the origin?
Right.
Okay.
So these are territories acquired by the government long ago, whether through conquest or by treaty. And the government, in that sense, owns the land. And so they do have a claim on the land. The traditional policy of the government, though, was to disperse the land, to get it into the hands of the people, whereas now the policy of the government is to control us through the land, and that's a different matter. So I don't want to defend...
I think that...
Go ahead.
Not at all, but Clavin Bundy makes the case that the government has the right to control the land under two conditions. Firstly, if it's a military matter. Secondly, if a territory is a territory as opposed to a state. Like, for example, Washington, D.C., and most of the states in our unions were territories before they became states. But he claims that once a territory becomes a state with its own constitution, then those lands become the purview of the state, and the state legislatures and governors then have the authority to decide how the land is going to be disposed of, not the federal government.
Right. Now, that's an interesting argument, and I confess I have not dug into it to know whether it's right or wrong one way or another. So I don't have any position on this. I'd have to do a lot of research. I tend to, as you'll see from my book, I tend to dig into a topic and try to dig it through, and that's not one I've studied.
Okay, now the other issue, and this is a news-driven program, so I need to ask you as a constitutional expert issues with regard to legalities in the news. President Obama, as we speak, has authorized and is conducting bombing raids over Syria. Now, my understanding is that there has been no congressional consultation, there's been no congressional declaration of war, certainly, and that he is openly and bluntly stating that he is deriving his authority from the United Nations Security Council. To my way of thinking, this is an extra-legal question because Article 1, Section 8, Clause 3 says that the Congress shall declare war. The President should go to Congress, ask for a declaration of war, and the Congress shall then declare war, and the President then, as the Commander-in-Chief, is empowered to conduct the war. That's what happened in 1941 when Franklin Roosevelt asked for and received a declaration of war against Japan. So where does President Obama derive this authority right now? Is this not an example of administration? Thank you very much. We're discussing administrative law, domestically primarily, with Professor Philip Hamburger, the author of Is Administrative Law Unlawful? And we're joined by Andre Traversa, my partner at EpiQuest Media. Andre, please go ahead.
Hey, Professor Hamburger, thank you for being on the show.
Thank you.
I guess I have two questions for you. One is, when a department issues regulations, and I realize that Congress has created these departments and they technically oversee them, but when a department issues regulations that are not specifically part of written law, of the law that Congress has written, would you call that, is that part of what you're talking about when you talk about administrative law?
Right. So what Congress will do is it will pass an authorizing statute for, let's say, the FDA or the EPA, and will include all sorts of vague language and opportunities for departments or agencies to make determinations. And then the agencies will fill in the gaps, as it were. And all that gap filling is a form of extra-legal lawmaking. Rather than have Congress write the laws, the agencies end up doing it. And they also, of course, exercise extra-legal judicial power in adjudicating violations of these regulations. That's right.
Okay. No, kind of a related question. In Canada, we have things like human rights commissions, and some states have civil rights commissions that are what are called administrative law courts. Now, what exactly? I've never been clear on this. What exactly is an administrative law court? Who are the judges on it? Are they appointed judges that are appointed by the executive branch in those states, or how does that work?
Yeah, what are those things? And this is not to comment on the substance of the policies enforced by any of these groups, but just to understand how it's imposed. Ordinarily, Congress is to make the laws. We live in a republic, and an elected body should be making the laws. And then courts, which are the opposite of elected bodies, which are staffed by judges who are meant to be intellectually independent in their judgment, actually decide whether we're guilty of violating them. And that way we're fully protected because we participate in the making of the laws, and we have genuinely independent judges appointed through a complex process to decide cases with the assistance of a jury. Administrative power avoids all of this. It's a giant evasion. Administrative law is made, or so-called, is made by agencies that are not staffed by people we elect. They're anonymous bureaucrats who are sort of an elite that we really have little connection to, and are influenced mostly by large corporations, not by individuals who elect them. And then we have administrative adjudication. These are called administrative courts, and they're said to be staffed by administrative judges or administrative law judges. But these judges are not nominated by the president and then confirmed by the Senate, as the Constitution stipulates. And their loyalties are not entirely to independence because they're attached to administrative regulations, and so they're not apt to find these unconstitutional. And they make decisions, of course, without a jury. I thought we had a constitutional right to a jury, not only in criminal cases.
Well, we have that in family
cases.
courts, too, unfortunately.
That's right. And, there's something very interesting here. Family courts apply a sort of law that is drawn from the canon law, which in turn is derived from the civil law. And administrative power also is that heritage. It's a continental civilian tradition, which is antithetical to the common law tradition. And interestingly, family courts are notoriously ineffective and notoriously slow and cause a lot of disruption. So all the injustices that we're familiar with from, let's say, traffic court and family law court is simply writ large in federal agencies. That's right.
Wow.
It's depressing. It's
Philip,
as if the DMV was our model. Sorry, go ahead.
You say that family law is derived from canon law. Isn't that from the Catholic Church? I mean, isn't that something that I suppose you could say it predates the Constitution? How could that work? I mean, I understand that, for example, the Magna Carta is still sort of the law of the land and that it predates the Constitution, but there's nothing in it that contradicts the Constitution. And you have that phenomena, in a sense, across the world. Napoleonic law is the undergirding of much of European law. Turkish law is the undergirding of Israeli law. You've got systems and layers of law that existed before the sovereign nation became a state that continues to be put in place. But how is it that canon law became a predominant foundation for American family law?
Well, that's a long story. Essentially, in the Reformation, the church courts in England lost their authority, and then Anglican ecclesiastical courts began to take their place, and eventually this all became a foundation for statutorily established family law courts. And so these are a bit of an exception to our general assumptions. But what you said about layers, I think, is very important.
We'll have to take one brief break here.
Sure.
We'll be right back. Philip Hamburger is my guest. Thank you, sir.
Turn to a pre-constitutional mode of government. English kings, Edward III or Henry VIII, were discontent to rule through the statutes and through the courts of law. And so they tried to bind their people through proclamations and tried to adjudicate their violations of these extralegal rules in extralegal courts. And the English Constitution in the 17th century rejected that, and the U.S. Constitution rejected this in the 18th century. And unfortunately, we've gone back to those pre-constitutional modes of government. And that's what really worries me. That's the heart of the book.
Right. In other words, we have a situation where if you've got settled law, so-called, which sort of, I don't know, I guess it goes back to St. Thomas Aquinas' idea of just laws, or just wars, as he called it in his Theologica, that these sorts of laws are not actually derived from the consent of the governed, which was a concept that eventually was came about and was manifested in our Constitution, and that's the underlying principle of the American system of jurisprudence: consent of the governed.
Yeah, we live in a republic. We live in a
right.
republic,
a republic and not a democracy.
Right, and the nature of a republic is that the laws are made by an elected body, and that is what is really that is the assumption that has disappeared. Now, of course, the defenders of administrative power will say, well, Congress oversees all of this, But that's actually a curious assumption. The assumption is that there are dangerous elements in society that need to be controlled. We therefore need expert agencies. And just as let's say, corporations are controlled by the agencies are controlled by Congress. But of course, it's not clear it just happens that way. Maybe it's actually the reverse, because administrative power, unfortunately, tends to be susceptible to influence by people with large lobbying firms and other modes of influence in Washington, not by voting. And so there's a risk often that corporations, especially the largest ones, actually tend to have more influence in regulations than vice versa. So, for example, the net neutrality rules were actually drafted by industry lobbyists, not by the agency. And then there's a risk that the agencies, in turn, actually have control over Congress. Rather than Congress controlling the agencies, very often the agencies can, through their distribution of benefits or through their regulations and adjudications, can affect the districts of various congressmen. And so the congressmen are somewhat beholden to the agencies. So it may be, rather than Congress controlling agencies, which in turn control us, it may be that large corporations have undue influence over the agencies, because, of course, the agencies are not elected. And then the agencies actually can influence the congressmen, in which case the entire theory is backwards. And of course, that's an empirical question.
It's interesting. Yeah, I mean, we found out that what you're saying is absolutely true when you had the BP oil spill in the Gulf of Mexico, and we found out that the bureau that manages oil licensing is entirely run directly and apparently by consent of Congress by the oil companies who
right.
Who were able to manipulate when and how this platform got its license.
Right.
So,
and the entire system of licensing lends itself to this sort of danger, as you suggest, and BP Oil is a good example of this. I don't want to pick on any one particular company, but the danger is that instead of having a law adopted by Congress, which states a general rule that we all must live by, the agencies control and have discretion over particular instances of deviations from the rule.
Okay, we'll be right back. Please sit tight. Philip Hamburger is my guest. You bet. This is Administrative Law Unlawful.
A Truth Talk defender.
Thank you very much. And my guest is Philip Hamburger, is the author of Is Administrative Law Unlawful? We're talking about, in a sense, the origins of law shifting from the consent of the governed through elected officials serving in legislatures, whether it be Congress, whether it be state legislatures, whether it be city councils, to these unelected bureaucracies that are run by private interests. There are many examples of this. I mean, on the national level, huge examples of this, of course, is the Federal Reserve System, which is a private consortium of banks that basically have been given partnership authority by the federal government in 1913 to issue currency at interest to the federal government and regulate the value of our currency. I would argue in direct contradiction to the Constitution, which says that Congress shall coin money and regulate its value. And also, you've got these other agencies, this recent development within the Department of Education called Common Core Curriculum. It's privately run by this, this consortium of educrats and various companies and private foundations like the Bill and Melinda Gates Foundation that are making policy with regard to the education of our children. In a sense, we've ceded that power from our elected representatives, in that case local school boards and states, to this unelected bureaucracy. What say you, Philip?
Well, yeah, there are layers of problems here, because once Congress lets go of the power to legislate, one place it can end up in is in the hands of the executive, and that's dangerous enough. But then there's another problem, which is when Congress shifts legislative power essentially to private bodies, so-called independent agencies. Now, some of these agencies are not really independent. They're partly under executive control. But many of them are not entirely executive, or at least have considerable private participation. And that's very odd. I had not known that under our Constitution, the rules by which we should live are made by others in the society. And curiously, many of these independent agencies are actually dominated by forces that are relatively powerful in the society, at which point it very much looks rather medieval, as if the government is simply shifting power from the weak to the powerful in society.
It becomes almost feudalistic. Okay, we're going to take one more break here. Apologize for that, Dylan. We'll be right back.
Most of us have pondered about the one universe.
Really too much to cover in one short hour. You've also written a book about the separation of church and state, which is interesting. Perhaps we could have you back on to discuss that. And in a nutshell, we're talking about how power has been transferred, and always the possibility of such power is transferable to unelected people who are not accountable, people who are not, we don't even know who they are. They are wielding legal power, not lawful power, legal power over the rest of us, both domestically and increasingly internationally. And that in that sense, we are losing control of our own lives and our destiny, wouldn't you say?
Well, there is a danger of that, and the odd thing is one doesn't want to go too far and say that we live in a terrible society. It's a wonderful society in many ways, but the risk is that as we lose a republic and create within it another system of government, one that reverts back to a pre-constitutional mode of governance, one that's more like royal government, there really is a danger that the whole society will be crushed under the weight of, and our freedom will be crushed under the weight of regulations. In science, which I'm particularly interested in, there's a danger that all our innovation is going to be slowed down as more and more of it gets into the hands of regulators, who often, although they claim they're experts, are actually rather behind the times in their science. It's as if the regulations were imposing the science of 10, 20 years ago. And this is really very unfortunate. It will affect the lives of all of us.
We're ruled by experts, ruled by professionals.
Well, supposed experts. I don't want to concede too much to them.
Right. No, I agree. But it's sort of a trend that really began, I think, in the early part of the 20th century with the development of a professional class of teachers and professors who, they sort of were able to derive certain governmental authority over first education and then other areas. And then, of course, you had in 1913 the setting up of the nonprofit foundations and the think tanks, where very, very wealthy people could park their money and employ themselves and their friends, but also wield great influence over our society, how we live our life. And there's been, since then, this gradual transfer to these panels of experts, so-called, as you say. Andre, would you like to chime in?
Yeah, sure. I want to go back to the administrative law courts, Phil. Again, I'm trying to understand, like, for example, back in New Mexico, you may not be familiar with this, but there was a civil rights commission there that ruled that it was discrimination for for a business to deny a wedding cake, a bakery to deny a wedding cake, or I'm sorry, it was a photographer who didn't want to photograph a gay wedding. Okay, so this civil rights commission, who runs it? These the judges on it, are they actually real judges with real law degrees, or what? Who appoints them? I mean, I don't. I mean, are they appointed by the executive branch in the state, or how does that work?
So it varies from state to state, but the key point, as you suggested, is that these aren't real judges. Sometimes they have law degrees, sometimes they don't.
Really? So they're just called judges?
They're called administrative law judges or administrative judges.
Even though they may not actually be judges, they're being labeled as judges.
None of them are judges.
Are you serious?
Well, a judge, at least under federal law, is someone who is nominated by the president and confirmed by the Senate, and that simply is not the case for federal administrative law judges.
No, but in states, though.
In the states, each state has its own mode of appointing judges, but usually commissioners and other administrative judges are not actual judges.
Wow.
But that gets worse because our rights under the Bill of Rights in trials includes not only to be tried with the due process of law in a court and with a real judge, but also, of course, to have a host of procedural protections, including juries. And there are no juries in administrative proceedings.
That's right.
And the whole point of a jury is to have a non-government official, in fact, a non-official, mere members of the community decide one's case. And that's very important, both as a political protection and also to ensure that the law, when explained to the jury, is of a clarity and simplicity that we can all understand it. The law gets insanely complicated, however, when officials who are steeped in the rulemaking are the ones who decide what the law is and then who apply it, because they're not just drawn from the community. So we now have government officials applying the law to us instead of having individual members of the community deciding it.
By the way, you mentioned family courts. I'm not against the idea in theory. I think there should be a way to resolve child custody disputes. But again, there need to be juries. Why aren't there juries?
Right. The problems with family courts are really rather depressing, I'm afraid.
Okay, we'll be right back to conclude. Philip Hamburger is my guest. Is Administrative Law Unlawful?
You have a mortgage and a load of other debt. Wouldn't it be great if it all just went away? 9-year mortgage can change your life.
We paid off all of our bills.
All your debt, including your mortgage, in as little as 9 years?
We will have saved over $313,000 in interest payments.
Even have more money left over each month?
It lowered our monthly payments by a little over $500.
9-year mortgage.
Where have they been all of our life?
If you knew about something like that, you'd want to tell everybody.
Whenever I have a friend or someone that needs this service, I give them the number.
Hi, I'm Larry Ruff, president of 9-Year Mortgage. This is unlike anything you've ever seen before, and it will absolutely not harm your credit. Call for your free CD and learn how you can eliminate all of your debt, including your mortgage, much sooner than you ever dreamed possible. The more debt you have, the more we can help.
Call for your free CD now, 800-383-5310.
This works. Call the number.
Call now for your free CD, 800-383-5310, 800-383-5310.
Chuck Morse speaks.
Thank you very much, and Philip. Excellent, thank you. Andre?
No, that's pretty much about it. I just think that what you're telling me is amazing. I had no idea that these people weren't actually judges. That's just amazing to me, and that's really scary because it's very Orwellian. Yeah. It's the use of words that mean things that they aren't supposed to mean. You know.
Yeah, my reaction to all of this, it was a learning experience studying this, and my reaction has just been to be depressed. Our government has been transformed.
Well, there are a lot of things to get depressed about in this world, so
True enough.
We should, Philip, we should have you back to talk about what we as citizens can do.
I look forward to
besides
that.
what we're doing right now. Yeah, I mean, right now we're doing our bit by, and I feel like I do that, by simply exposing the situation, educating people, educating myself. But I'd like to talk further about practical steps we could do as citizens that are reasonable and within the system to challenge this situation. So, Philip, again, I want to thank you for joining me this afternoon. My pleasure.
Thank you very much.
Andre, take care.